Sorry about that. I'm having a couple technical today, so apologize there. I'm gonna start over here, but anyhow, we have a small group today, so if you folks would like to just make this more of a conversation, we are certainly open to that. So feel free to ask questions as we go along. You can unmute yourself, you can raise your hand, you can type in the chat box, whatever you're most comfortable with. But what we wanted to do today is this is our second stakeholder meeting related to the Charter School Facilities Program regulation amendments to clarify and provide some more detail on how the process would work if a facility that was funded under the Charter School Facilities Program will no longer being used for charter school purposes by the original occupant of the facility. We had some regulations that already spoke to the process at a broad level, but the regulation changes that we have, they are going into a little more detail on that. So we had raised this issue back in February, and we did have a stakeholder meeting to provide our initial thoughts on the process. We actually have two districts and schools that are kind of going through this process for different reasons right now. It's been not quite 20 years, but we haven't had a lot of these occur in the lifespan of the program. But we have had the opportunity recently to kind of take a look at this because we do have some folks that are needing to exercise this option in the regulations and the statute. So we had a stakeholder meeting back in February 2021 to get some initial feedback on the process. We've gone over the regulations and then we got some public comment. And the public comment, we really appreciate you guys all for weighing in on this process, and we got some questions. We have gone back as a state and worked as the state agencies and with our legal counsel to see what we can incorporate into the regulations and what our limitations may be for some of the suggestions that we did here. So that's the point where we are at today. We have had those discussions. We've got the revised item out there, and we have included a new cover item to explain any of the comments or feedback that we were not able to incorporate into the regulations. So what I thought we could do today is we can touch on it and kind of walk through the comments we heard. We will kind of walk through those questions that we got and explain where we landed on those particular topics. We'll show you the change we made from the item that you saw back in February to now, and then we can just open it up to further discussion. If we don't have any additional stakeholder comments that we can incorporate, the next step from here would be for both state agencies to take these regulations to their respective boards. So we would be, right now we're targeting June, but it's going to kind of depend on the outcome of this meeting. So so I've got the item up here. I did want to let you guys know we had a little numbering issue on the second page of the cover item, so I apologize, and I'll help guide you through that as we get there. But we did not make a lot of changes to this version of the regulation. There was one section that you'll see highlighted that did incorporate some additional detail in the event that there were multiple charter schools that were wanting to occupy the facility. But we had heard a lot of comments related to who controls the process of selecting the successor charter school, what happens to any additional funding that was provided by parties outside of the state and outside of the matching loan, and some requests for how to do this that we did actually encounter some statutory challenges with some of the asks. So that's one of the overriding themes on some of these answers. So before I get started into the details of the particular comments that we received, did anybody have any questions on process? Anything else we want to address before we dive into the weeds here? Or Katrina, did you have anything you wanted to add on?
No, I'm having a little trouble with my mic, so I'm not sure if folks can hear me very well. I mean, I guess we know most of the folks that joined. So Nick is on from CCSA, Marnie is on from School Solutions. Site Solutions?
School Facility Consultants, right, Marnie?
Yes, School Facility Consultants. Yes, thank you.
So I guess to your point earlier, Barbara, if folks kind of want to you know, provide any feedback before we get started, or, you know, provide some context. As you know, we're working through the transfer of one facility right now with LAUSD. So we're kind of learning real time about, you know, the succession and how to implement those provisions in the ed code. But in this situation, the district is taking more of the lead, as it's, you know, it's a district site. The site is held, you know, by the district. So there's, you know, the state's playing a slightly different role than we might under another fact pattern. So, you know, if folks have any kind of lead-in comments or questions, you know, feel free to weigh in now. I guess we can get started, Barbara.
All right, sounds good. Okay, so I am just going to kind of walk through our cover item here. So you'll see that we've got sort of the description, the background. So we're kind of starting towards the bottom of the page there. And one of the questions that we did get originally out of this last meeting was if it would be possible for multiple schools to use the facility. So sometimes these facilities, you know, they're built for 500 students, but maybe we have 2 charter schools that are interested in the facility, but applying on their own, they don't really need the whole space, and they wouldn't necessarily be able to afford the whole space off of 250 students. So we do believe that that would be fine if we have 2 schools that would be interested in applying to be the successor charter school for those purposes. And what we have added to the regulations is we would see this as one partnership. So we don't want to get into a situation where you've got 2 different schools that have never heard of each other, that, you know, we would have to work out a lot of details. But if 2 schools come together, submit a request to be the successor charter school, then that would be fine, be considered one application. We'd be looking at both schools for financial soundness type purposes, making sure meeting the other requirements. But then the question came up was, well, if you've got 2 different schools, we've got preference points that are outlined in the successor charter school provisions. So whose points do we use? And that is actually the regulation amendment that you will see in the yellow highlight there. And what we are proposing there is a simple majority. So the school that has more enrollment in the grade levels for which the facility will be used, if they have the majority of the enrollment, that is whose preference. Keep that we use, because sometimes we have maybe it's a K-12 charter, but this is only going to be for the 6-12 portion of that charter school. So we don't want to use the full K-12 enrollment because that wouldn't make sense. We're just looking at that 6-12 enrollment compared to the other charter school that's going to be joining that applicant. And if, you know, whoever 6-12 enrollment is bigger in that particular case would be the applicant whose preference points are used. I will pause there for questions on this particular topic. I'm not seeing any hands. And again, feel free if you guys want to unmute. It's okay, just jump right in. We're a fairly small, friendly group. Okay, I'm not seeing any questions there. It's not your only opportunity. You can come back to it if it comes to you at the end, so feel free. I'm going to go back to our stakeholder item here, and then moving on to the second topic. And this one kind of spans both pages here. So the question came up, oops, let me get to where I can see the answer here. We did get a question, so more so, not necessarily related to the successor charter, but we had a request for clarification on what happens to the first charter school that was in that facility. When are they basically off the hook for the payments? When is their obligation over? And can we add some clarification in the regulations for that? So we did take a look at that to see whether there needs to be a regulation change for that, but the charter school agreements actually already discuss this. So there are provisions in the agreements that talk about the liabilities of the original charter school and when they are no longer liable for payments or obligations under the agreement. So this is covered in those documents. So we did not make any changes to the regulations because we feel this is already covered in the charter school agreements, but the answer for those that have not been in the weeds on those agreements every day for the past 15 years, right? Once the charter school has given up their rights to that facility and they're no longer occupying it, then their obligations end under the agreements. So that can mean different things depending on the circumstances. But in the case we're dealing with right now, the charter school intends to be done at the end of this particular school year. They're going to be done, close out the school year, and then they're going to vacate and basically turn that facility back over. So they're not obligated past that point at which they've turned the facility back over. And we believe that the agreements do state that. So that is why we did not do a reg change on that one, but should be covered on the charter school agreements. Any questions on that topic? Not seeing any hands. So moving on to the third point that was raised. This was related to those that have made a further investment in the facility or the property. So we've got some charter schools who have used the charter school facilities program funding, used the loan, the matching share, or have done a contribution equivalent to the matching share. But then there are some folks that have gone above and beyond those dollar amounts, either to complete the project as designed or to add on or to just do, other things, other improvements to the facilities. The ask was if there was a point at which the original charter school or those that had made those investments in the property had an opportunity to be reimbursed if the facility was going to be taken over by a successor charter school. And we absolutely understand where folks are coming from on that. We did take this one back to legal as well. There is a role for what's called a significant contributor in the program. That's been there since the very early days of the program. However, the significant contributor role comes in at the end when the charter school facility is no longer being used at all as a school facility. It ends up being, if it ends up being disposed of during the surplus property provisions with either the district or the state, if the district declines to dispose of the facility, would dispose of the facility, and then from the proceeds that are available after that sale, that is the funding that can go back to a significant contributor. So because the statute already has that spelled out in where that comes in, we don't have the ability in regulations to move that time point earlier. So if somebody has contributed and it becomes a charter school for a different entity, then that significant contributor can still have an interest, but the charter school would be using the facility and funding coming back to that significant contributor, and unless that facility is ultimately disposed of and taken out of use for school purposes entirely. And anything we do in regulations has to be lined up with the statute. So there wasn't really a spot where we could change that at this point through the regulatory process. And as for if folks have contributed to complete the construction of the facilities, I think a comment we heard back in February, it just kind of is what it is. The program doesn't contemplate that there is additional contribution above and beyond the state share plus the local matching share, either through the loan or through the contribution there. So it's not structured that way. So we also don't really have any room in the statute to provide any sort of funding out of that. Also, there isn't really isn't a mechanism to reimburse. So there's no dollars that are necessarily available that would even be in play if this is going to a successor charter school, because that's just moving from one applicant to the next applicant. So there's no state dollars that were necessarily available or district dollars So we don't see a way at this point to make any changes to the regulations to allow for any sort of reimbursement at the transfer stage. And then the statute would already cover when it would come in if the site was disposed of. Any questions on that one? Okay, not seeing anything there. Number 4, so here's where our numbering starts to go off a little bit, and I apologize for that, but the question here, it was more of a statement, but number 4, the statute did not delegate a role in the process of selecting a successor charter school to the state. OPSC and CSFA and our respective legal counsels do believe that because we are administrators of the program and we oversee the bond funds, that we have an obligation and a role in the process of selecting a successor charter school. We don't believe that this is something that can be turned over solely to school districts or solely to a charter school. And that kind of ties into the next comment, which is listed as number 6, that the entity that holds title to the facility should be responsible for identifying the successor charter school. And here again, we point back to the Ed Code, and while title is allowed to be held by school districts, by a local governmental entity, or in the event that it's not held by a school district or a local governmental entity, the charter school, that section, that is one section. So folks can hold title in different ways, but the succession provisions also talk about who is ultimately responsible for the disposal of the site. So at the end of the day, the school district, or if the district declines to dispose of the site, then it goes over to the state. So both the district and the state have an obligation at the end of the day to address this facility and either make use of it or have it sold. So there are specific provisions there. The other thing that is in play here is that there's a remainder interest to the school district, which once that first charter school is not using it for charter school purposes, then that remainder interest kicks in before the successor charter school is selected. So we are seeing in the statute both a role for school districts and for the state in the successor charter provisions. We don't see anywhere where it would allow the original charter school to pick the successor charter school, and we don't see a place where the state is removed from this process, and we don't see a role where the state is really doing this without partnering with districts to some level. So the way the regulations are written now and how we've actually been proceeding is in partnership. So school districts and state working together to ensure that the process for selecting the next charter school is in alignment with the program regulations, it's in alignment with the statute, with the goals of the bond funds. And I know we all take our roles very seriously as administrators of these bond funds, and the goal is to use them for their intended purposes and in alignment with the statute. So we can assure you that that is our goal, and that's how we plan to work through this process. And so that is why we have the regulations drafted as they are, which does allow for some input by districts and some input by the state. And that actually kind of takes us through the majority of the comments we got, takes us actually through what is listed as it's listed as number 8 and 9 there, but basically we are seeing that the statute has already outlined this process to a certain extent about who has the ultimate responsibility. So we did not make any changes to alter that in the current regulation proposal. I know that one was a lot to digest because I think I just threw 3 topics at you. So let me know if that needs clarification or if there are any further questions. Okay, still not seeing any hands. So I'm moving down to the third page of the item related to number 10. So this is moving away from who is selecting the successor charter school, and this gets more at some of the preference points categories for the next few topics. And we had a question that charter schools that are currently authorized should receive preference. The regulations already require that charter schools with approved petitions be notified of the availability of this project and site. So we are not seeing that a charter school without an approved petition would actually be part of that notification process. So earlier in the item, we also had clarified, so we're interpreting this. So if folks feel that we're not quite getting the question, please also feel free to let us know. But we believe this has already been covered. So if you are an authorized charter school, you can participate in the program. You would be notified. You'd have an opportunity to compete for the facility. If you are not authorized yet, you don't have an approved petition, then you would not be able to at this time point. The next question or request stated to remove the preference for a charter school serving the same grade levels as the constructed facility. And then basically whoever the successor charter was would be responsible to modify the facility to have it meet its needs. Oops, apologize. The preference it's an allowable category, but not a requirement. So if the district, and this is in the district category. So if you remember from February, we had the state preference points and we had the district preference points. And in the district category, this could be used to select a successor charter school. We believe that this should stay as a potential preference because sometimes the district's in-house student certification is tied, well, not sometimes, when the district's making the in-house student certification, it is tied to particular grade levels. The facilities are constructed for the grade levels, so there may be a connection there, and in some cases it might make sense that this would be allowable as a preference. So we left that one. And then the next one related to preference for charters that serve district students and have that be removed. And that again was an allowable category, not a requirement. We left that one still in the district's request section for the preference points. Again, because it is tied to the in-house pupil certification. So there may be a case where new construction eligibility was used or modernization eligibility was adjusted. So there could be a tie there between the district students and what the district originally agreed to for the project. And I will pause there for a second because they're tied to the same thing. Any questions on those two? And sorry, 11 and 12. All right, 13. So this, we actually had a pretty robust conversation about this back in February about where we would put the preference for students, district students versus kids coming from outside of the district but attending the charter school that's located within the district. The ask was for the state to include that in our preference categories as opposed to a school district. If you'll remember, the regulations are structured evenly, right? So the state has their preference points and then the district is allowed to establish preference points, and it can't exceed. Basically, they either have to be even or we've written it so that the state's preference points would be higher. So by moving that category, it would change that threshold a little bit. We don't believe that that it would be consistent with how the state administers the program to make it a preference of the state for it to be in-district students to have a preference to that particular facility, because the program itself serves more than that. So the program identifies the school district where the project is going to be physically located and that serves the same grade levels as the project that's proposed. That is the district when we're thinking about the charter school facilities program. But there are many ways that a charter petition can be approved. So it could be a COE approved charter, it could be a state approved charter. It could, the charter petition itself could allow for students that are coming from multiple areas. And because that's allowed in the program, we don't feel that it's appropriate for the state to say that we are going to provide a preference for students that are being served by the district. We understand why that might be something that districts want to do, and there potentially could be a rationale for a district to consider that in their preference points, but it would be inconsistent with how we administer the rest of the program for us to make that a priority in our preference points. Any questions on that one? No? Okay, so moving on to number 14. A clear process for selecting a successor charter school should be established by the state. Answer to that is we hope that we're doing that through this regulation process. One of the things that we have been looking at when we're doing these regulations is that there's probably not a one size fits all process for every school district, because every school district is different. Some school districts have hundreds of charters in them, some have one. So we wanted to make sure that the regulations would work in multiple scenarios. So we were trying to balance the more detailed process that provides a clear system with making sure that there was room to address the unique requests or aspects that might be involved in particular school district charter school areas. So hopefully that's what these regulations are doing. So they're intended to provide guidance on how that process occurs. What we really wanted to ensure here is that it was a fair process, that it was notified, that's eligible. There's conversations between the state and the district so that we're all in agreement about how this is moving forward. We hope that that's what we've created here with these regulations, but if not, we're open to further suggestions on that. And then that ties in a little bit to number 15, talking about the state should notify all charter schools authorized to operate, even if authorized by an entity other than the school district. We believe that the school districts in most cases will be better able to notify the charter schools in the area. We, of course, back to the prior conversation, we would be involved in this process if a successor charter school is necessary. So we would be monitoring to make sure that this is an agreement, but yes, and we think the districts will do this. Now, obviously, there is the exception. There are a couple of cases we know of where local bond dollars have contributed to the project, restricting who can be in that facility. And so we have to think about things like that. But for the most part, we would expect that the districts, when doing the notifications, would make that available to all eligible charter schools. And that could include those that are not just the ones that are authorized by the school district. So it is the intent that this goes as broad as possible so that everybody can compete. And the state obviously has an interest in seeing it happen that way. So we will be making sure that we work that direction with districts, but also districts have a good connection with charters in their area, like who all these folks are. So, and also districts and charters, you get an email from the state, sometimes that gets overlooked. You get an email from the district, you've got a resource there. So we did leave it with the district. We think that's the best place for it, but we're not seeing that that's going to be an issue at this current point. So most folks have good intent with how they are going to participate in this program and following the statute and following the regulations. So we're hopeful that will be a good outcome. Let's see here. That was the last comment we had there. Again, it's page 7 of the regulation, page 7 of the item. with the highlighted section of the regulations, that is the change from the February version to this version. And that is just letting folks know that if you apply jointly, again, it's the charter school with the higher enrollment based on those grade levels that are going to go in the facility. And just like last time, the CSFA and the OPSC regulations align, so it shouldn't read differently if you're looking at one agency's successor charter provisions versus the other agencies. And with that, I am going to open it up to questions about what we've got so far, or if anything came to you between February and now, or if you heard something in February and you feel like it wasn't adequately addressed. Please let us know now. This is your time, so we'd love to hear from you.
Hi, Barbara. I just want to say thank you for all of your work on this, and Katrina as well. It sounds like the situation with the school in LA is headed in a good direction, so that's good to hear. Also, to the extent that you all are interested in addressing some of the code issues or statutory issues that prevent you guys from doing things a little bit differently, perhaps, as some folks have proposed or suggested, and you're interested in working on that, we'd be happy to help in that and have further discussions on how we might make some of those changes. We know there are competing bills working through the legislature right now to place a bond measure, a statewide bond measure on the ballot in 2022. That might be one opportunity, but it probably be others. So let us know how we can be helpful in that regard, please. Thank you.
Thanks, Nick. We are tracking those bills internally. Ryan Story is tracking those for us, so we will probably be circling back with Barbara and Aaron and their team. And that's a great idea in terms of looking for ways to improve the program.
And give it just another second here, even though it's quiet. I was participating in a different meeting on Zoom the other day, and it was moving so fast I couldn't type my comments fast enough. So I don't want to do that to anyone. So we'll just give another minute while you're forming your thoughts if you have questions. Next couple days that you didn't think of, or if you need more time with the item in the regulations, if you want to send us an email, either any of us, Aaron, me, Katrina, Michael Pack, anyone who I think we've got the contact info listed in our meeting notice there, but you all know where to find us. So if you have comments that pop up in the next 2 days, feel free to let us know. Otherwise, next steps for this would be the respective board meetings in June. It would come out with the normal agenda packets as a board item. From the OPSC standpoint, we do this as sort of a cover item and provide the feedback. The format will look a little bit different, but the comments that have been made by stakeholders will be summarized much like you see them today. Oftentimes we are just directly translating it over to feedback that we receive. We might put some headers on there as far as grouping it for our board members so they know the general topics, but it won't be a big departure from what you've all seen for our first 2 stakeholder meetings when we take it to the state allocation board. So that would be the next step for these regulations. And then they go through the rulemaking process, and we'll have those in place so that hopefully next time this happens, if it does happen, we've got a nicely outlined process for identifying that successor charter school.
Barbara, did you
Any
want to
parting
give
thoughts, last words? Go ahead, Lisa.
excuse me, I'm sorry. Did you want to give like a date out there before we finalize the item for June for public comment?
Yeah, ideally in the next few days would be great. Today is Wednesday. If you know that you're planning on submitting, we've got Memorial Day coming up, don't we? If we could get it by June 1st, that would be very helpful because it will allow us some time to respond to you if it's a clarification or to incorporate it into the item. The getting things on the agenda, as you all know, takes a little bit. We've got to get the items cleaned up, get them ADA remediated, get them up on the website and noted in certain timeframes. So if we could hear from you by June 1st, end of day, I think that would be very helpful on our end. Thanks for reminding me, Lisa. That's a good point. All right. Okay, Katrina, any last thoughts or?
No, I think that's it. I think you've done a great job covering everything, so we appreciate it. I don't know, Michael or Tom, if you had anything.
No, I don't have anything to add.
Aaron, anything I left out? Nope, I have nothing. All right. Well, again, we thank you all for joining us today. We really appreciate it. We really value the feedback. We need you guys here for these, so thank you for making the time. And with that, I think that concludes our meeting today. So everybody have a great day.
Thank you.
Thanks.
Thank you all.